All right, we have two cases here before the court involving the same defendant, both titled State of Ohio versus Virginia A. Beal. Present for the state is Assistant Prosecuting Attorney Adam King, and present on behalf of the state, or the defendant, is Attorney Sarah Barger. You're Virginia A. Beal. All right, in case number 24 CR 132, the defendant has entered a plea of guilty to aggravated possession of methamphetamine, a 5th-degree felony. In case number 25 CR 20, she has entered a plea of guilty to the same charge, but it's a 3rd-degree felony. The court ordered a pre-sentence report, which I have received, and of each of the attorneys had an opportunity to review a summary.
Yes, Your Honor.
All right. Anything from the state regarding sentencing?
Only what's contained in the plea agreement, Your Honor.
All right, Ms. Barger.
Just what is contained in the plea agreement, Your Honor.
All right, Ms. Beal, is there anything you'd like to say?
No, Your Honor. I'm glad to have a home, I can tell you that. All this came about being homeless and not knowing boundaries, but learning through my therapy that I do every week. Just going to continue recording and doing what I'm supposed to do and being thankful to have a home. So I don't have to go through this ever again.
All right. It's your the court then that you be sentenced to a term of 3 years of community control supervision under the supervision of probation department. The conditions are as follows. You're to obey all laws, all jurisdictions, conduct yourself in all body, manner, at all times, report when and as directed. You're to be truthful in all statements that you make to the probation department regarding your supervision. Must keep them informed of your residence and place of employment, if any, at all times. You may not change either without prior permission. You may not leave the state of Ohio at any time without prior written permission. You may not enter upon the grounds of any correctional facility, nor may you communicate with or attempt to communicate with anyone who's an inmate in any of those facilities without prior written permission. Now, because of your convictions in these two cases, you're not permitted under either federal or state law to purchase, possess, use, or have under your control any firearm, ammunition, or dangerous ordnance. If you were to do that, that would subject you to being prosecuted for an additional felony. It's also a condition you not have any weapons of that nature or any other type while on community control in this case. You're not permitted to purchase, possess, use, or have under your control any controlled substance, drug abuse, CBD, oil, kratom, or any variant or analog of any controlled substance that has an effect similar to those, nor may you have any instrument, device, or thing that may be used to administer drugs or prepare them for administration unless you have a lawful prescription, a copy of which must be provided to your supervising officer within 24 hours of receipt, and to submit to drug testing when and as directed. You may not purchase, possess, use, or have under your control any alcoholic beverage, nor may you be present in places where they're sold or being consumed, even if otherwise lawful. You're not permitted to associate with anyone who has a criminal record, as a member of a gang or any other criminal group, or any person who has in the past or could in the future influence you to commit a violation of these conditions or criminal offense. That also applies to any family members that may fall within that definition, unless you're living with them immediately before the commission of these offenses. After the date of this order, you're not permitted to marry or establish cohabitation in the common law marriage type relationship with another without written permission. You must report any contact with law enforcement or any arrest, citation, conviction, or other charge of violating the law not later than the next business day after that occurs. You must provide your supervising officer with financial information records so your ability to pay any costs can be reviewed. If you're referred by the probation department for further evaluation or assessment for any other type of treatment beyond that which you're currently getting at REACH, or if it's recommended by REACH, you're to submit to that. And if there's a recommendation you undergo additional treatment or programming of any type, you're to enroll in and successfully complete that. You pay the court cost and make payment arrangements to do that. You'll be required to successfully complete your outpatient treatment plan and aftercare through REACH. Now, by being placed on community control rather than being sentenced to prison, you're deemed to have consented to a search without a warrant of your person, residence, vehicles owned by you or used by you, or any other property place that's under your control where you're about at any time, any officer of the probation department. There'll be no fine or driving suspension imposed, and you're currently you're receiving disability, and how much is that?
1,022 a month, Your Honor.
All right. Well, the court will find that defendant doesn't have the ability to pay the mandatory fine and will not likely in the future, so that is waived. You're also ordered to pay the court costs as a substantive order, and if you don't make payment arrangements and pay in accordance with that plan, the clerk of courts can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then it could be referred for collections, and if that occurs, you would have to pay an additional 30% for the collection fee on top of the cost. If that doesn't collect it, the court could order you to do community service in this county and give you credit for each hour you worked in an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. Now, in the event that the probation department feels that you have not complied with these conditions, they will file a written notice of that with the court. You'll get a copy. There will be a hearing. The outcome of that, and you'll be entitled to have an attorney. If the outcome of that hearing is that you have failed to comply, then at that time the court can revoke your community control and sentence you to a period of 9 to 36 months in 25 CR 20 and 6 to 12 months in 24 CR 132. If that occurs, once you complete your sentence, it is possible that the adult parole authority could put you under what's called post-release control supervision for a period of up to 2 years. If they do, you'll be supervised on the terms they set by a parole officer. And if during that period of time they determine that you have not complied, then they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony, then in addition, whatever sentence a judge in a new case imposes upon you, that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that has to be served consecutively to the sentence of the new case. All right. Is there anything further with counsel?
No, Your Honor.
All right. That completes your case, then, Ms. Beal. So you're to report to probation officer over here for appointment to be transferred over to felony supervision. You're no longer under house arrest, but the new conditions I just went over with you are the ones that will apply. All right. Thank you. All right, this is State versus Rachel N. Simpson, 24 CR 166. Are you Rachel Simpson appearing there on the screen marked Alexei Beneke?
Yes, sir.
All right. This is a hearing being conducted by Zoom on a plea on motion for intervention. Ms. Simpson's attorney is Sarah Barger, appearing from her office, appearing from the prosecutor's office is Prosecutor Collins. Ms. Barger, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in front of the court?
Yes, Your Honor.
Okay. And that's all right with you, Ms. Simpson?
Yes, sir.
All right. If at any time during this hearing you need to speak with your attorney, since you're not in the courtroom seated next to her, just tell me and I'll put the two of you into a breakout room so it'll be just the two of you on the screen. No one else will be able to see you or hear you. Okay? All right. Now, Ms. Simpson is charged in a one-count indictment with possession of a fentanyl-related compound, a fifth-degree felony. The defendant filed a motion for intervention in lieu of conviction, and the court ordered a report, which I have received, and my understanding you are currently at Jalissa's house at the Recovery Council in Piketon?
Yes, Your Honor.
All right. And the report indicates that she's otherwise eligible. And I have been presented then with a form of plea of guilty and an entry granting intervention in lieu of conviction. And I'm going to hold this up to the screen. The first page has your case name and number and plea of guilty to count one. I'm going to ask you if you recognize that on the camera.
Yes, sir.
All right, and on page 3, there's a sentence that says, I enter this plea voluntarily. Right below that appears to be signature Rachel N. Simpson, 4/23/25. Hold that up to the screen, Cameron. Is that your signature and the date you signed it?
Yes, sir.
All right. Now, Ms. Simpson, I'm sure that you've gone over this with your attorney, but I'm required by law to make sure that it's on the record that you understand what's going on here. Normally, it's proposed here that you're going to plead guilty. Normally, when a person pleads guilty, the court sentences that person. Could be in this case, a term of incarceration of 6 to 12 months and a fine of $2,500. And then that, or it could be community control, which is probation. And then once that sentencing entry is filed, that person then is convicted of the felony, and you would have a felony record. Now, there is a procedure under the law that provides that if a person's drug abuse or substance abuse was a significant factor in the commission of their offense, and if they are in a treatment program like you are now, that person can plead guilty, but instead of being found guilty, the plea would be held and the case would be stayed, which means it doesn't go forward, and there'll be no finding of guilty. And then you have the opportunity then to complete an intervention plan, which you currently have for your treatment for your issues. And then it's required by law that you comply with certain conditions of the program that the court has approved and are for the probation department to follow. And those, there are several of them, 7 or 8 conditions maybe, but there's not as many as there are if you would be convicted and on probation for a felony, and they're not as stringent. But basically, the 2 primary ones are you must complete your treatment plan successfully, and you must abstain or not use any kind of alcohol or drugs for a period of 1 year, a minimum of 1 year, unless you have a lawful prescription. And then you have to comply with the conditions that I have adopted. Now, the advantage to you of this program is that if you plead guilty and are put into this program, and you successfully complete it, then even though you pled guilty, your charge is dismissed and you do not have a conviction, because even though someone could look in the file and see that you pled guilty, since there's no finding of guilt, it's not a conviction. And so that's what this allows you to do, is to avoid being convicted of a felony if you successfully complete your program. So the disadvantage is that this is your last opportunity to actually fight the charge and contest it. And so if you plead guilty, then you don't get to come back if you don't succeed and say, well, now I want to have a trial, because that's what this program is about. So, you understand that?
Yes, sir.
All right. So this document I have in front of me says you're going to plead guilty to the charge of possession of a fentanyl-related compound under 2925.11a of the Higher Revised Code, a fifth-degree felony. It carries a possible sentence in this case of 6 to 12 months and a fine of incarceration and a fine of $2,500. And you understand that?
Yes, sir.
You're not facing any felony charges anywhere else, are you?
No.
And you're not on
Yes, sir.
you're not on probation or community control for a felony.
No, sir.
All right. Now, in the event that you are put into this program and you successfully complete it, like I said, then the charge against you is dismissed. However, if the probation department and the state notify the court in writing that you have failed to comply, in their opinion, you'll be given a copy of that notice, and then the court will set a hearing, and you'll have an attorney to represent you at the hearing. If the outcome of that hearing is that you have failed to comply with either your treatment program or with the conditions of supervision, then at that time the court can terminate you from the intervention program, and since you've already pled guilty, then there will be a finding of guilt entered. And at that time, there would be a sentencing hearing, which could be, as I said, 6 to 12 months of incarceration, fine of $2,500, or it could be community control. And community control, like your intervention plan could go for 5 years, but I usually just follow for 2. Community control is also a 5-year program, and it's similar to what you're going to be on, except, as I explained earlier, once you have a felony conviction, your supervision conditions are more of them, and they're more stringent or strict. But this process works the same way, is that if the probation department during the period you're on community control, if that were to happen, feels that you're not compliant, then again, they file a written notice of that with the court, give you a copy. You have the right to have a hearing and an attorney. If the outcome of that hearing is you fail to comply, then at that time you could be sentenced to the 6 to 12 months, fine $2,500. And if you are convicted of a new felony while on community control, then and are sentenced for a term of incarceration in that case, those sentences could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes, sir.
All right, now, Ms. Simpson, the charge against you alleges that on or about August 24 of 2024 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, fentanyl-related compound, in violation of Section 2925.11a of the Higher Revised Code. So that's the charge against you with the penalties I've described. You understand what it is you're charged with, what the state said you did, when, where, how they alleged that you did it.
Yes, sir.
And you understand the possible penalty if convicted.
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible offenses you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and confidence in this matter?
Yes, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, has anyone promised you anything other than the promise that you would be granted intervention if you pled guilty here today?
No, sir.
Now, did you enter into this agreement voluntarily when you signed it?
Yes, sir.
And since it's been a couple of weeks, do you still want to do this, or have you changed your mind?
I still want to do it, sir.
You're doing it voluntarily.
Yes, sir.
Okay. All right. Now, you have certain constitutional rights well, let me back up. Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in the state of Ohio?
I have my CNAs.
All right. Is that still active?
I'm not quite sure.
All right. Well, a plea of guilty is not a conviction, and so as far as the court's obligations, nothing will happen. But if you are eventually convicted, if you were, as I explained, you don't comply and we go through a hearing and it's found that you failed to comply and you're convicted and then sentenced, then at that point the clerk of courts is required by law to send a copy of your conviction to the licensing board so that they're aware of that, so they can determine if they want to take any action against your license or not. They don't have to. The court's not saying that they should. We're just required to let them know that it happened. So that could be a possible effect if you are convicted in the future. You understand that?
Yes, sir.
All right. Now, you have a number of rights that you need to understand before I accept your plea. The first is that you have a right to counsel. Ms. Barger was appointed to represent you. Now, her appointment isn't simply to work the case out, but is to provide any defense that might be available to you under the law that you would like her to provide. So, if you decide that you do not want to do this, that you would rather defend against the charge, she will continue to represent you and defend you, including a trial if that's what you want. Do you understand that?
Yes, sir.
Under the Constitution, Ms. Simpson, you have a right to have a jury trial in this case, in which 12 people would be chosen from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After 12 of those individuals are selected, the evidence is presented, and then they're instructed on the law by the judge, and then that jury of 12 people decide by a unanimous verdict, meaning all 12 have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you did want to plead guilty, you can waive in writing, which means to give up, your right to have a jury trial, and in that case you would have what's called a court or bench trial, and that means instead of a jury hearing the evidence, the judge would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. What that means is that the witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that is to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, same as the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order, it's called a subpoena, and that forces those people to come to court to be able to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, sir.
Now, under the Constitution, Ms. Simpson, you have a privilege against self-incrimination. That means that you cannot be forced to give evidence against yourself at any time, in this case, including the trial. So no one could ever make you testify. The prosecutor can't, the judge can, it's up to you. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there is a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider that for any purpose. Do you understand that?
Yes, sir.
Now, in the Constitution, Ms. Simpson, you're presumed innocent of this charge till proven guilty by the state of Ohio on every essential element of the offense charged. What that means is that the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of the offense charged by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Right now, originally your plea that was entered for you was not guilty. That not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights I have just described. If you change your plea today from not guilty to guilty, that is the opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime. That plea would waive and give up all the rights that I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. Well, with that exception, your plea of guilty would waive and give up your right to a jury or court trial, waive and give up your right to confront the witnesses against you and to cross-examine them through your attorney. It would waive or give up your right to use the power of the court to compel or force witnesses to be in court to testify for you, just like the state. It would waive or give up your privilege against self-incrimination because you're the one that's saying you're guilty, and that's what's used to find you guilty. It waives or gives up your presumption of innocence because if you say you're guilty, then the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you feel you may have had up until this point in the case. Now, if I should sentence you at some point in the future to the maximum sentence or under other limited circumstances, you could file an appeal. It would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen, Ms. Simpson?
Yes, sir.
Now, do you have any questions about the charge or the penalty for that charge?
I don't think so, no.
And you understand it?
Yes, sir.
Have any questions about this procedure that we're going through with the intervention and what's going to be required?
I don't think so, no.
All right.
Sir.
Do you have any questions about the plea agreement then, that you're going to plead guilty in exchange for being put into this program?
No, sir.
Okay, you understand that?
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
Do you understand them?
Yes, sir.
You understand what the plea of guilty means, what will happen if you enter that plea here today?
Yes, sir.
Now, is there anything you need to speak with your attorney about before we go any further?
Maybe one thing.
Okay.
I just have a question.
All right, I'm going to put you in the breakout room, which means that there'll be just the two of you on the screen here in a moment. There's going to be an icon that pops up that says Join Breakout Room. You click on that. When you're done, you will click Leave the Breakout Room, and you go from there. Okay. All right, we're back on record. Okay, we're back on record on State versus Simpson. Thanks. Now, are you have any other questions, Ms. Simpson?
No, sir.
All right, then is it your decision to go forward with this written agreement we've gone over and enter a plea of guilty to the charge?
Yes, sir.
Okay. Then as to the charge, which alleges that on or about August 24, 2044, in Highland County, Ohio, you did knowingly obtain, possess, or use Schedule II controlled substance, to wit, fentanyl-related compound, in violation of Section 2925.11a of the Ohio Revised Code. The charge of possession of a fentanyl-related compound, a fifth-degree felony, carries a possible term of incarceration of 6 to 12 months and a fine of $2,500. How do you plead?
Guilty.
All right. The court finds that on this day in open court, the defendant was advised of all of her constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Plea is accepted and ordered filed. The court finds that the defendant's drug usage was a factor that led to the offense for which she has entered a plea, and that intervention in lieu of conviction will not demean the seriousness of the offense and would substantially reduce the likelihood of any future criminal activity by the defendant. She is currently in an appropriate certified treatment program through the Recovery Council. She's otherwise eligible for community control, is not a repeat or dangerous offender, is otherwise eligible, as indicated by the stipulated questions that were filed. And therefore, the court will find that the defendant's plea of guilty is accepted, but that it will not be, a finding of guilt will not be entered. Rather than the criminal proceedings will be stayed. The defendant shall be placed under supervision of the probation department under the community control term for the intervention program for a period of 2 years. She will also be required to successfully complete the intervention plan, including the requirement she must abstain from using drugs or alcohol for a period of at least 1 year, comply with all the terms and conditions that have been set forth by the court and by the probation department for the program. And if she's successful, she will also be required to pay the cost of the proceedings plus an additional $50 for a sealing fee in the future if she successfully completes the program. In the event that the defendant is alleged to not comply with the not being in compliance with the treatment plan and/or the conditions of supervision, upon written notice from the probation department or motion by the state, the court will hold a hearing to determine whether the defendant has failed to comply, at which time she'll be represented by counsel. And if the outcome of that hearing is that the defendant has failed to comply, then at that time the court will enter finding him guilty and could sentence the defendant at that time for 6 to 12 months and fine her $2,500, or place her on community control. All right. Now, that completes the proceedings, Ms. Simpson. So you're no longer under the bail conditions of pretrial supervision and so forth, or house arrest. You'll be required to comply with those conditions. And Officer Benson, would you be in contact with her to go over that, or how do you want her to handle that?
I'll email them down there the conditions.
Okay. All right. So she'll be sending it down there, and you'll need to go over those and sign it, and then go from that, go on from there. All right. Is there anything further from counsel?
No, Your Honor.
All right. Thank you. All right, who do we have there at the jail? They're not connected to the audio yet. All right, good morning. Who do we have there at the jail?
Ronald Beckley.
All right. All right, this is case number 25 CR 62, State of Ohio versus Ronald D. And how do you pronounce that, sir?
Not your last name. Oh, Neckley.
Neckley? All right. Well, I know some people up here, they pronounce it Kennelly. So, but anyway, Mr. Neckley, you were indicted by the grand jury yesterday on a charge of failure to register a change of address as a registered sex offender, violation of section 2950.05 F1 and 2950.99 of the Ohio Revised Code. And essentially, indictment charges that beginning on around February 10th of this year and then continuing after that in this county, that as a registered sex offender convicted in Brown County in case number CR 12016-2153, and having a duty to register, that you failed to do that, and that the conviction was for importuning, which is a 5th-degree felony. And you are registered as a Tier 1 sex offender that was required to register annually and 20 days before an address change, within 3 days of an address change if applicable. So that is a 4th-degree felony and carries a possible term of incarceration if convicted of 6 to 18 months and a fine of $2,500. Now, you are entitled to have an attorney, Mr. Neckley, to represent you, and if you don't have the money to hire one, the court will appoint one for you. I don't see a financial disclosure statement. Did you fill one out for this arraignment?
Yes, sir. He filled one out the other day and sent it with the return.
Oh, okay. So it was sent up earlier? Okay. Let's see. Well, we don't have the return. All right. But I'll just assume you've been in jail since you were arrested. Is that right, sir?
Yes, sir.
All right. And you have no income?
I agree with you.
Okay. We'll need to look for that. It's in the return, apparently. All right. Well, the court will go ahead and find then that you are entitled to appointed counsel. And Mr. Kirk was the one who represented you previously, and he is present here today. So, Mr. Kirk, you are appointed, and I believe you handled his preliminary hearing. Is that correct?
That is correct.
All right. So, how did your client plead then?
Enter a plea of not guilty and would waive reading of the indictment.
All right. All right, and the state's represented by Prosecutor Collins in this case, I should note. Does the state have any position on the matter of bond?
The state is recommending a $7,500 bond. We would note that this is a failure to register a change of address, so Mr. Netley's whereabouts were unknown until he was arrested on a warrant for failing to register a change of address. Thank you.
Mr. Kirk?
Thank you, Your Honor. He's been under activity with the exact bond out of the municipal court. He's not able to make that, and as he has no address, we would make no argument on bond other than if I find out additional information, I can file something in the future.
All right. Then the court will set the bond at $7,500 plus your own recognizance, which is your promise to appear, Mr. Neckley. And if you fail to comply or to appear as required, you could be prosecuted for an additional felony if convicted, sentenced on that, no matter what happens in this case. You'll also be required to pay a deposit of $171 prior to release to cover certain statutorily required fees. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You'll report to them immediately on your release, Report to them once a week for 4 weeks. After that, as they determine, undergo random drug testing they may order. If recommended by probation, be evaluated for substance abuse or mental health issues. If any treatment is recommended, you'll enroll in and follow that during the pendency of this action. And you'll also be under house arrest at your residence, which means you have to be there at all times unless you're working, going to and from work, court proceedings in this or any other case, appointments with an attorney, probation officer in this or any other case, medical treatment, schooling, any kind of job training, college classes, etc., or church services. Other than that, you have to be there at all times. If you fail to comply, that could result in the bond being revoked and being held till further hearing of the court. All right, your first pretrial will be set for May the 21st.
Your Honor, I'm pretty sure I'm out of town that day. I want to make sure that I'm here.
All right.
Yeah, I am. I'm out the 20th through the 23rd.
All right. Well, then we'll move it up a little bit because I think we have a June 30 trial date on this. So let's see. You'll be here. You say you're out the week of the 20th?
I'm here the 19th, and then the 20th to the 23rd I'm out.
Okay, 19th. Let's see here.
I think I'm in next week too. On the 14th, I have some hearings there, but we may already be full that day. I don't know.
Well, that had been set aside for civil cases, and we don't have any scheduled that day. So, what time would you be available on the 19th?
Looks like I could do either 11 in the morning, or we could do anything in the afternoon.
Let's do 11 a.m.
Okay.
And that'll be by Zoom. All right. And then final pretrial then would be set for June the 4th at 1 p.m. And trial date will be June the 26th at 8 a.m. All right. Anything further from counsel?
No, Your Honor.
Okay, Your Honor.
All right. Thank you. Would you bring in Michael Certain next, please? All right. Are you Michael W. Certain appearing there from the jail?
Yes.
All right. This is a hearing on a capias was issued in case number 25CR25. And then Mr. Certain also has 3 additional indictments to be arraigned. Mr. Certain's attorney is Damon Davis, and he is appearing. This is being conducted by a video, presumed, so he's appearing from his office and appearing from the prosecutor's office, Prosecutor Collins. Now, we'll address the current case first, 25CR25. The defendant failed to appear on a hearing date, and so the court issued a capias, which brought him back before the court. There was a $50,000 bond in that case, and my bailiff informed me that the bond company had called, I think Monday, when Mr. Certain was picked up, whatever day it was he was picked up, and indicated that they wanted to be off the bond, and he was directed to contact the clerk's office, and we have not seen any written request on that yet. But in any event, I'll hear from the state regarding bond.
Your Honor, we would ask for a $150,000 bond in that case. We would note that Mr. Certain failed to appear in court. Prior to him failing to appear, he had multiple violations of pretrial supervision. He was not reporting. He tested positive. The court advised him that if he did not do as he was told by probation, that you were going to revoke his bond. he didn't enter treatment as probation requested, and then instead he just absconded. The task force was able to track him down in Ross County. He wasn't in Highland County anymore, and they were able to make an arrest on him at another location. So based on that, we would ask the court to revoke the prior bond and issue a new bond in place with $150,000.
All right, Mr. Davis.
Your Honor, we would ask the court for a bond akin to what Mr. Certain previously had. He has limited financial resources at this point. His home was a victim of an arson this week, so he's pretty much lost.
There was no evidence.
Well, it was burned, is what I was told. Well, it was burned down, is what I was told. So, Your Honor, we would ask for something akin to the $50,000 that the court previously said.
All right. The court will set bond the amount of $100,000, and that would require, if the current bond surety was willing to continue, an additional $50,000, and if not, it'll require $100,000. And then the same conditions as previously ordered, pretrial supervision. Now, I believe we had had a final pretrial on this, haven't we already, Ms. Collins?
Yes, the trial is actually set for next week.
Okay. Well, I think since it was off the docket and he's been, I mean, I assume you're not going to be prepared to go to trial next week, Mr. Davis?
No, Your Honor. My office actually just mailed out a jury to the prosecution for the discovery yesterday.
Well, I was on the new cases, I think.
Your Honor, for the record, on the new cases, we have not been retained yet. I'm certain my office has a call set up with some of his associates at 2 p.m. this afternoon. So that could change, but I will represent him for the purposes of bond right now.
Okay. All right. Well, but discovery, did you get the file from the previous attorney when you entered the case?
I got paper. I didn't have a drive that day to get everything that was given to him electronically. So I have not received that.
Okay. So I guess going back to my question, then, are you prepared to go to trial next week, or are you requesting?
No, Your Honor.
Okay. All right. All right. So let's see here. Well, since Mr. Certain failed to appear, obviously he was just taken into custody. I believe at least the court was notified on Monday. All the time from the time of the capias until this new trial date, the speedy trial time, told until the new trial date. And let's see, what are we looking at? Is this maybe a 2-day case, Ms. Collins, you think? Six different events, it looks like.
It's 6 different events, but it's a task force case.
Okay.
It'll be, I think, one day. We definitely can prove in our case one day.
All right. What about June the 23rd, Mr. Davis?
What time will we start that day, Your Honor?
We start at 8:15.
8:15. Yes, I'm available.
All right. Actually, 8 o'clock. I'm sorry. I usually see the attorneys at 8:15, but I want everybody here at 8. So, all right. So the new trial date then would be June the 23rd at 8 a.m. All right. Now we'll go to the arraignment on the other cases. And Mr. Certain, from what Mr. Davis has indicated, you haven't retained him yet. That apparently he's discussing that with someone here later today. So for today's purposes, he'll represent you for the arraignment and the bond, and then we'll set the matter for a pretrial status conference to find out what that is here in a few days. So let me look at these cases chronologically. Let's see. Case number 25 CR 59. That case, Mr. Certain, you were indicted on April the 1st and charged with having a weapon under disability and a forfeiture specification. And that offense is a third-degree felony, and then the forfeiture seeks forfeiture of a weapon. Mr. Davis, do you wish to have the indictment read?
Oh, yeah, I will wait and read it.
All right. And how does your client plead?
I do.
Okay. All right. Now, with regard to the next case is 25 CR 75. And in that case, Mr. Certain was indicted yesterday on 4 counts. Count 1 is aggravated trafficking of methamphetamine. Count 2 is aggravated possession of methamphetamine. Count 3 is possession of a fentanyl-related compound. Those offenses are alleged to have occurred on the 28th of January. And then tampering with evidence is alleged to have occurred on January 28th as well. And there are 3 third-degree felonies and 1 fourth-degree felony there. All right. And Mr. Davis, do you wish to have the indictment read?
Oh, yeah, I will wait and read it.
And I'm not sure, I didn't say it, but I'm not sure when Mr. Certain was served with the indictments from yesterday, but if it was less than 24 hours ago, do you waive that as well?
Yes, sir.
All right, thank you. And he enters a plea of not guilty?
Yes.
All right. I forgot, are you from Columbus, Mr. Davis?
My office is out of Columbus. I'm out of Cincinnati.
Cincinnati, I'm sorry. Yeah. All right, and then with regard to case number 25 CR 76, Mr. Certain was indicted yesterday on a charge of failure to appear. I believe in the 25 CR 25 case, it was the case that we started with at this hearing. That's a fourth-degree felony. And do you wish to have an indictment read on that, Mr. Davis?
No, we'll wait for you to include any defects of service to the short file.
All right. All right. I'm going to set all these for a status hearing. And if you're not retained in those cases, Mr. Davis, then you won't have to be present for those, for that. And we'll deal with Mr. Certain then at that time, whether he's appointing other counsel or if he is going to request court-appointed counsel for those cases. So we'll set the status hearing on that for May the 21st.
Your Honor, I would definitely not be available if I am retained.
If you are retained and enter your appearance, then the hearing will be off.
Okay, thank you.
Okay.
If I may, Mr. Davis has entered his appearance in the 59 case.
In which case?
25 star 59.
Oh, okay. So you're on those two cases. All right.
So the cases even prior, already indicted on. Yes, so that's fine.
Well, that was the 25 case, and then there was a case, the one that we reigned on the weapon under disability. And yes, you did enter an appearance and request discovery in that case. All right. All right. So we'll just do the status hearing then on the other two cases for the 21st at 1 p.m. And again, if you do enter an appearance, then the hearing will be vacated. And if you don't, then I'll go forward with Mr. Certain to determine what the situation is from him as to his counsel in that case. In those two cases, I should say. And that'll be a Zoom hearing. All right. Now, with regard to pretrial in those two cases and the weapon under disability, I'll put those all at the same time just in case you do end up representing him. What, are you available on June the 4th, Mr. Davis? That'd be a Zoom hearing.
I'm on vacation that week, Your Honor.
All right. So you're available the following week?
Yes.
All right. Let's see. That'd be the week of the 9th. How about the 11th? A Zoom hearing. That'd be in the.
Yes, I'm available for that.
It'd have to be in the afternoon, 1 o'clock.
Yes, Your Honor, that works.
All right. So 11 o'clock on the 25th. June the 11th at 1 p.m. by Zoom. Then final pretrial, we'd be looking at July the 2nd. And are you available then, Mr. Davis?
Yes, Your Honor.
All right, so we do July the 2nd at 1 p.m. And then the trial in the first case, which is the 59 case. And what I'm going to do, I'm going to set all three on the same date, but understand that those would not likely be tried together unless the parties agreed. We'll be looking at, how about July the 21st, Mr. Davis?
Yes, Your Honor.
All right, so July the 21st, all cases will be scheduled that day at 8 a.m., but subject to change, separate dates unless there's a joinder either agreed to or ordered by the court after motion filed. All right, now, with regard to bond on those cases, all right, we'll start off with the 59 case. Well, I'll just hear it on all three cases. So, Ms. Collins, your state position with regard to bond.
59 case, Your Honor, we are requesting a $15,000 bond. And in the 75 case, we're requesting a $50,000 bond. And in the 76 case, we're requesting a $10,000 bond. And I would note that a good guidance for bond is the defendant's the promise that he will appear in court. Mr. Certain shown that he will not do that. He has to be found after warrants are issued and bond forfeitures are filed. I think based on his prior history, a more substantial bond in these cases is called for.
All right, Mr. Davis.
Your Honor, Mr. Certain is likely not to make the bond set in the previous case, so we would ask for a reasonable bond as it relates to these cases. Maybe an electronic monitoring requirement if the prior case were resolved before these charges were to trial.
All right, bond will be set in the 25 CR 59 case at $10,000 plus OR and $171 or $116 deposit for the statutory required fees. In case number 25 CR 76, it'll be set at $10,000 plus OR and the $116 deposit. And in 75, it'll be set at $20,000 plus the $116 deposit, and same conditions as original in the first case, pre-trial supervision, and abide by all of those. All right, anything further then from counsel?
No, Your Honor.
Nothing from the defense, Your Honor.
All right, thank you. Okay, 25 CR 66, State of Ohio versus Yash Kumar Patel. Is that correct pronunciation?
Yes, sir.
All right. Mr. Patel is appearing from the Justice Center by Zoom. This is an arraignment being conducted remotely. And his attorney that I'm going to appoint, assuming he qualifies, is President Danielle Witt, and representing the state is Prosecutor Collins. Ms. Collins, has the alleged victim of victims of the crime crimes charged been notified of the time, place, and purpose of this hearing, the right to be heard?
And she has been notified, Your Honor, and is not participating. We will notify her of the outcome after the hearing.
All right. Now, first of all, Mr. Patel, you do have a right to have counsel on this matter, and if you don't have the money to hire one, the court will appoint one for you. I know Ms. Witt was appointed for you in municipal court, and you did provide a financial disclosure form here. And is everything on your form correct?
Yes.
And this indicates you live in Ontario in Canada?
Yes, sir.
Okay. All right. Then the court will appoint Ms. Witt to represent you. And Ms. Witt, I know you handled the matter at the municipal court. Do you need to have the indictment read?
No, Your Honor.
All right. You waive the reading of the indictment then?
Yes, we do.
All right. And you waive the 24-hour reporting period as well?
Yes, Your Honor.
Waiting period? All right. And how does your client plead?
He pleads not guilty.
All right. Let's see here. There we go. All right. The first trial in this matter then will be set for May the 21st at 1 p.m. final pretrial will be set for June the 4th at 1 p.m. And then trial date will be set for June the 26th at 8 a.m. All right. State wishes to be heard on the matter of bond.
Your Honor, we would ask the court to impose a $250,000 bond. We would note the defendant is not a citizen of the United States. He has a visa from Canada. He's here on a B2 visa, according to ICE. There is absolutely, he has no ties to the United States other than this alleged crime. So based on that, as well as the nature of the offense, we would ask the court for a $250,000 bond.
All right. Ms. Witt?
Yes, Your Honor. We do ask the court for a reduction in bond so that Mr. Patel may try to be able to meet that bond. I do believe that he has no prior criminal convictions.
Well, given the fact that Mr. Patel is a non-resident, and given what's happening with people being shipped out of the country almost overnight, I'm concerned about him being deported and then we'd never be able to bring him back. So I'm going to go ahead and set the bond at $250,000 plus an own recognizance, which is your promise to appear, Mr. Patel. To appear, you could be prosecuted for an additional felony if convicted, sentenced on that, no matter what happens in this case. You'll also be required to pay a service fee deposit of $171 prior to release to cover certain statutorily required fees. If you do make bond, you'll be under pretrial supervision of the probation department, and you'll be required to report to them once a week for 4 weeks, and then after that, as they determine, I must undergo random drug testing, provide phone numbers for home cell employer, have no contact with the alleged victim, recommended by probation to be evaluated for substance abuse or mental health issues, any treatments indicated you're to enroll in and follow that during pendency of the action, be under house arrest at your residence, which must be local, and you may not leave the state of, you may not leave Highland County while you are on bond, if you do make bond. And if you violate any of those conditions, the court could revoke that bond and have you held till further order of the court. All right. Anything further, counsel?
No, Your Honor.
All right. Thank you. All right. I think All right. Are you James Stephen Fetro? Oops. Are you James Stephen Fetro appearing there from the jail?
Yes.
All right. This is case number 25 CR 78, State of Ohio versus James Stephen Fetro. Mr. Fetro, you were indicted by the grand jury yesterday on 23 counts total. Count 1 is a charge of engaging in a pattern of corrupt activity, and it alleges that occurred between June 1, 2024 and December 31, 2024 in this county, that you, along with Katie Joanne Fetro and other indicted or unindicted co-conspirators, have engaged in a pattern of corrupt activity by participating in the affairs of an enterprise. And that is a first-degree felony, which carries a mandatory sentence of between 3 and 11 years as a minimum, and a potential maximum of 16 and a half years, $20,000 fine, $10,000 mandatory fine. And then you're indicted on numerous aggravated trafficking and aggravated possession of drugs in the remaining counts of the indictment. Those are various degrees. Some are fifth-degree felonies, which carry 6 to 12 months and a fine of $2,500. Some of them are third-degree felonies, carry a possible prison term of between 9 and 36 months, fine of $10,000. And in count 16 and 17, those are first-degree felonies because of the amount alleged. And those, again, are mandatory prison term of 3 to 11 on each, minimum, a maximum 16 and a half plus the fines. And then it looks like the forfeiture specification in count 23 seeks to forfeit certain property alleged to be involved through the criminal enterprise. That includes $48,297 in currency or real estate at 9477 Pigeon Roost Road, a number of weapons, looks like about 8 weapons. And if convicted, that results in the loss of that property to the state. All right, Mr. Fetro, you're entitled to have an attorney to represent you on these matters, and if you cannot afford to hire one, the court will appoint one for you. Are you intending to employ your own attorney?
I'm not sure yet.
Okay.
Because the funds that I would have to do that, she already took.
All right. Do you have any other property of any type? Other real estate or businesses or anything?
I just have own part of the property.
Okay.
I don't own the whole thing.
All right. So, are you? What do you want to do? Are you asking the court to appoint counsel for you? I've reviewed your financial disclosure form. Is everything on that form correct? Other than I don't think you listed the other piece of real estate that you own.
I didn't really understand all of it, so I just filled it out as well as I could last time.
Okay. Well, who do you own that property with?
My mother.
And what kind of property is it? Is it farmland or house or what?
No, it's on the edge of Hillsborough, where Shaw TV used to be a long time ago. There's
Oh, okay.
Right behind there.
Oh, okay. All right. Well, do you wish to try to employ an attorney, or do you wish the court to appoint one for you at this point?
Well, I'm probably going to have to get out and talk to some of them first before I actually know, to be honest with you. I don't know any other way to answer you, really.
All right. All right. We'll go ahead and move forward and wait to hear on that. So at this point, the court will just enter a plea of not guilty for you in the absence of counsel. And I should note that Prosecuting Attorney Collins is also present for this arraignment. Ms. Collins, state wish to be heard on a matter of bond.
Your Honor, we filed a recommendation of a bond of $250,000. We would note the serious nature of these charges. By my calculation, this is a maximum of 41 years incarceration. Most of these charges carry, a number of these charges carry mandatory prison sentences. And based on that, we would ask the court to impose a $250,000 bond.
All right. Okay, the court will go ahead and set bond the amount of $250,000 plus own recognizance, which is your promise to appear. And if you fail to appear, then you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. We'll set a status hearing on the issue of your attorney, whether or not you're going to be able to hire your own counsel, or if you wish the court to appoint one for you. If before this hearing you determine that you can't hire your own attorney, you'll need to notify the court through the sheriff's office, and then the court will appoint an attorney at that time. But for the time being, we'll set the status conference for, let's see here. Today is the 7th. We'll set that for May 14 at 1:30 p.m. That'll be a Zoom hearing. If you do get an attorney before that, the hearing will be off. Or if you notify the court that you can't hire your own attorney, then the court will appoint one for you, and we won't need to have the hearing. And then once you do have counsel, we'll set a bond review hearing. Your first pretrial will be set for June 4 at 1 p.m. Set the final pretrial for June the 25th. At 1 p.m. And we'll set the trial date for July the 10th at 8 a.m. All right. Now, Mr. Petro, if you do make bond, you'll be under pretrial supervision probation department at 117 East Main Street. So you'll report to them immediately upon your release. You have to report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing, they may order, provide phone numbers for home cell employer, have no contact with the co-defendants in this case, Mr. Starkey and Ms. Petro. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment is indicated, you enroll in and follow that during the period of this action. You'll also be under house arrest at your residence, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case. Can attend appointments with an attorney or probation officer in this or any other case. Can also attend church services and any kind of educational programming. And if you fail to comply with those conditions, then the court could revoke that bond and have you held to further order of the court. All right. So you'll be remanded to custody pending posting a bond. And as I said, if you do make contact with an attorney and they enter an appearance by next week, or you notify the court before that you can't obtain counsel, then we won't need to have the hearing. We'll go ahead and put an appointment on for you. Do you have any questions, Mr. Fetro?
Yes, about the money that was taken from my premises. I could hire an attorney if I had that, because I even had the paperwork already showing where all the money went through the bank from the business to me.
Well, that's something you'll need to take up with an attorney because it's subject to forfeiture right now, and so if it's subject to forfeiture, then it's not available to you. So once you get an attorney that the attorney feels that there's anything can be brought before the court on that, the court will hear it. But at this point, I'm not in a position to do anything about it. All right. Anything further?
Not from the state.
All right. Thank you. All right, Mr. Starkey, please. All right, are you Christopher D. Starkey?
Yes, sir.
All right, Mr. Starkey, you were indicted on May the 6th, yesterday, on 2 counts of aggravated trafficking in drugs and aggravated possession of drugs, a 5th-degree felony, each of them 5th-degree felonies. Those that are alleged to have occurred, along with James Stephen Fetro and Katie Joanne Fetro, and that's allegedly occurred as count 18. The other counts are against Mr. Fetro and Ms. Fetro. Count 18 is that it occurred alleges on about September 6th of last year. And it's alleged to be psilocybin mushrooms. All right. You're entitled to have an attorney to if convicted, you could face a sentence of 6 to 12 months incarceration and a fine of $2,500. Now, you're entitled to have an attorney to represent you, Mr. Starkey. If you don't have the money to hire one, the court will appoint one. I see you have filled out a financial disclosure form. Is everything on this correct?
I believe so, yes.
All right. The court then will find that you are entitled to appointed counsel. I'll appoint attorney Danielle Witt to represent you, and in the absence of counsel, I'll enter a plea of not guilty on your behalf. We'll set a bail review hearing for Friday the 9th at 8:30 by Zoom. First pretrial will be June the 4th at 1:00 p.m. Final pretrial will be June the 23rd at 1 p.m. And then the trial will be set for July the 10th at 8 a.m.
Did you mean to say June the 23rd?
Yes.
That's a Monday.
Oh, it is?
Yeah. You set the other one for the 25th.
Yeah, okay. Yeah, I'm sorry, June the 25th. Yeah, I was not reading my writing. All right, correctly. All right.
What was the jury trial date?
July the 10th, the same date as Mr. Fetro for now. All right, and the state's recommendation is $5,000 bond.
Yes, Your Honor. We just asked for that.
I'm going to set it at $2,500. This is an alternative count, I believe, which would require an election, and I believe this is a House Bill 86 case. Don't think he has any prior convictions, does he?
Nothing I'm aware of.
All right. So your bond is $2,500, Mr. Starkey, plus OR. That is your promise to appear, and if you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that, no matter what happens in this case. You'll be required to pay a deposit of $171 to cover certain statutory required fees. If you make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. You'll report to them immediately upon your release, and then once a week for 4 weeks, and after that, as they determine, undergo random drug testing, provide phone numbers for home, cell, and employer. Have no contact with co-defendants, which would be K.D. Fetro and James Stephen Fetro. If recommended by probation, you'll be evaluated for substance abuse or mental health issues, and any treatments indicated. You'll enroll in and follow that during the period of this action. You'll also be under house arrest at your residence at 2545 can't read that. Is that Edgington Road? Is that Edgington Road?
Edgington, yes.
Okay. In South Salem?
Yes.
And that means you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational programming, classes, etc. You may also attend church services. If you fail to comply, then the court could revoke that and have you held till further order of the court. All right. We'll notify your attorney of her appointment. If you do make bond, you can get her phone number from the sheriff's office there, and you can contact her to make an appointment before your next pretrial. Although if you're still in jail on Friday morning, if you make bond, there won't be a hearing Friday morning. But if you don't make bond, then we'll have that hearing. That'll be a Zoom hearing. But she may not have time to get to you before Friday. All right. Do you have any questions?
With the work restrictions, you said
You're allowed to go to and from work, and you're self-employed, I see. Is that correct?
No, I'm not. I work for an electrical company, but did I not fill that out?
Yeah, it looked to me like it said Christopher Starkey on the employment, but in any event, you're allowed to go to and from work. All you have to do is let the probation department know where you're going to be and when and that type of thing, and so that you can only go to and from work. If you have to stay out of town overnight, you can do that, but you've got to let the probation department know where you're going to be. All right. All right. Thank you. All right, Kate.
Right?
All right, this is case number 25CR79, State of Ohio versus K.D. Fetro. Are you K.D. Fetro appearing there from the jail?
Yes.
All right, Ms. Fetro, you were indicted along with James Stephen Fetro and Christopher Starkey in a 23. You were indicted in 19 counts, including a first-degree felony of engaging in pattern of corrupt activity in count 1 that allegedly occurred between June 1 and December 31 of last year in this county. And then the other 18 counts would be 9 counts of aggravated trafficking and 9 counts of aggravated possession. 2 of those counts are in 16 and 17 are first-degree felonies, along with count 1. If convicted, those carry a mandatory sentence of at least 3 years up to 11 years as a minimum, with a maximum of up to 1/2 of the term imposed by the court, which means it could be a maximum of 16.5 years on each of those 3 counts. And then the 5th degree, others are 3rd and 5th degree felonies. Those 3rd degree felonies are punishable by between 9 and 36 months and a fine of $10,000. And the 5th degree felonies are punishable by 6 to 12 months incarceration, $2,500 fine. And you're entitled to have an attorney to represent you. If you can't afford to hire one, the court will appoint one for you at no cost. And I believe you have filled out a financial statement. I've got my paperwork mixed up here. All right, so I see you have filled out a financial disclosure form, and everything on that's correct. You're not employed? No. All right. I'm going to appoint Attorney Catherine Hapner to represent you in this matter, and Deputy, I'm going to change the appointment in Mr. Starkey from Ms. Witt to Mr. Kirk, because I don't think they could have co-defendants. And so Mr. Kirk's going to be the attorney for Mr. Starkey, if you would let him know that, please. And your attorney will be Catherine Hapner, and I will enter a not guilty plea in her absence for you. We'll set your bond review hearing for Friday morning, May the 9th at 8:30 by Zoom. Your first pretrial will be June the 4th at 1 p.m. Final pretrial will be June the 25th at 1 p.m. And your trial date will be July the 10th at 8 a.m. Prosecuting Attorney Collins is present for this arraignment. And Ms. Collins, the state have a bond recommendation.
Your Honor, the state is recommending a $150,000 bond in this case. While this veteran doesn't have a substantial prior criminal history, I'm not actually aware of any criminal history as an adult. Again, she's charged with very serious crimes, and by my calculations, facing about 37 years in prison. A substantial amount of that is mandatory prison time because of the charges. So, based on that, we would ask the court for a $150,000 bond.
All right, court will set the bond amount of $150,000 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony, and if convicted, sentenced on that no matter what happens in this case. You'll also be required to pay a deposit of $171 for certain statutorily required fees. If you do make bond, you'll be under pretrial supervision of the probation department at 117 East Main Street. Report to them immediately on your release, and then once a week for 4 weeks after that, as they determine, undergo random drug testing they may order. Provide phone numbers for home, cell, and employer, not to have any contact with your co-defendants. I understand Mr. Fetro is your father, but you're not going to have any contact if you do make bond. If recommended by probation, you'll be evaluated for substance abuse or mental health issues. If any treatment's indicated, you're going to roll in and follow that during the pendency of this action. You're also going to be under house arrest at your residence to be determined. And that means you'll have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings in this or any other case, appointments with an attorney or probation officer in this or any other case. You can also attend any kind of job training, educational programming, classes, etc., or church services and medical appointments, if I didn't say it already. Other than that, you have to be there at all times, and if you fail to comply, then you could have that bond revoked and be held till further order of the court. Do you have any questions, Ms. Fetra?
Yes, Your Honor. So, my bond hearing is May 9th.
Your review hearing is May the 9th, yes, that morning.
All right, and I heard something about, whenever the officers were talking about bonds, they said if it's like $50,000, that you would have to pay 10% of that, or something.
I set bond at $150,000 plus your own recognizance.
So
It'll have to be $150,000 of value filed with the clerk. That can be either through cash, surety, or real estate, as approved by the clerk. So I don't know how much bond will cost you, but you'll have to contact the bondsman for that information. I do not know what it would be.
okay, I just didn't know like how any of this works.
Well, I just explained it to you. So, you have any other questions?
I'm going to be in here until the next bond hearing, am I?
Unless you post your bond.
Okay.
If you post your bond, we won't have that hearing. It won't be necessary. But the purpose of that is to review the amount of the bond and the conditions set by the court once you've had an attorney to consult with.
And if I'm on house arrest, how am I able to not talk to my father if we live in the same house?
You won't be able to live in the same house. You'll have to find another location, I guess. Or if he's not there, if he's in custody, you could live there. But two of you can't live in the same house, so since he owns it, I would assume that you would have to find someplace else to live. But you're not going to live with him because he's a co-defendant in this matter. Any other questions?
Is Christopher also a defendant?
I'm sorry?
Yes, Christopher started to yes.
Yeah, yes, he is. Yeah.
So I'm not able to even talk to him?
No? Okay, any other questions?
No.
All right, thank you. This is case number 25 CR 48, State of Ohio versus Christine Kinnison. Ms. Kinnison, if you can get yourself on the screen there. A little bit more. That's the other way.
That's her.
Oh, that is her? Oh, okay, I'm sorry. All right. I didn't realize that. I'm sorry. I apologize. All right. And Mr. Wagner is connecting to audio. Said they were having some technological changes at his office yesterday. But maybe the changes haven't been completed. Mr. Wagner, you may want to log out and log back in because you're still connecting and we don't have an audio connection apparently. Okay, I'll take us off record here. Yeah. All right, are you Sebastian Kane Blount appearing there from the jail?
Yes, sir.
All right, this is case number 23 CR 104, State of Ohio versus Sebastian Kane Blount. It's Blount, right? Or is it Blount or Blunt?
Blunt.
Blunt, I'm sorry. Blunt.
It's okay.
This is a Zoom hearing. Mr. Blunt's appearing from the jail. His attorney is Catherine Hatner, appearing from her office by Zoom. And appearing on behalf of the state is Prosecuting Attorney Collins. The defendant is charged in a single count of aggravated possession of methamphetamine. This is a pre-trial. Trial is set for the 26th of June. Now, I have been presented with a plea of guilty form. So before I address that, Ms. Hatner, are you and your client both in agreement this matter can be conducted by Zoom rather than in-person appearance in the courtroom?
Yes, we are.
And you're okay with that, Mr. Blunt?
Yes.
All right. Now, Mr. Blunt, I've been presented this plea of guilty form, which indicates you're going to change your plea from not guilty to guilty. I'm going to show the first page to you on the camera there and ask you if you recognize that. It has your name and case number and says plea of guilty.
Yes, sir.
And on page 3, there is a line that reads, I enter this plea voluntarily. And right below that, there appears to be a signature, Sebastian Blunt. Is that your signature there on page 3? When did you sign this, Mr. Blunt?
Sir?
When did you sign this document?
Yes, sir.
When you signed it, did you understand that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case is going to be a sentencing hearing?
Yes, sir.
And before you signed it, did you go over with your attorney and ask her questions and have her answer those and explain things to you? And do you feel that you had enough time to fully consider the matter before making this decision?
Yes, sir.
And you signed this agreement voluntarily?
Yes, sir.
And you still want to go forward with it today voluntarily?
Yes, sir.
All right, so the agreement says you're going to plead guilty to the charge of aggravated possession of methamphetamine under Section 2925.11 of the Ohio Revised Code, a fifth-degree felony. States on page 1 that you understand that the maximum penalty could be 6 to 12 months of incarceration, fine of $2,500, and I don't think the license suspension applies anymore, does it, Ms. Collins? Okay. So that's, I'm going to mark that out since the law just changed. Or it could be community control. You understand that?
Yes, sir.
And are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, community control, parole, post-release control for a felony?
No, sir. Go ahead.
Pardon me?
No, sir. Not here. No.
Well, but any other jurisdiction?
Georgia.
Oh, in Georgia. Okay. All right. All right. Now, in the event that you should be sentenced to prison for this offense, upon completion of that prison term, the law provides that you could be put under post-release control supervision for a period of up to 2 years. If that happened, you'd be supervised under the term set by the Adult Parole Authority, and if during that period of time they determined that you had failed to comply, they could return you to prison to make you serve an additional period of up to half of your prison term for one or more violations. However, if you commit a new felony, then in addition to whatever sentence the judge in that case could impose upon you, the judge could also sentence you for committing that offense while under post-release control in this case to an additional period of a year or whatever time is left on that period of post-release control, whichever is greater. If that occurred, that would have to be served consecutively to sentence in the new case. Do you understand that?
Yes, sir.
Now, as I indicated earlier, this is a case in which community control is possible. That's what we call probation. And what that means is that instead of being sentenced to prison, you'd be sentenced to a period of community control under supervision of the probation department under the term set by the court, which could be for up to 5 years. If during that period of time probation felt that you were non-compliant, they would file a written allegation of that with the court, give you a copy. There would be a hearing. You'd be entitled to have an attorney at that hearing. If the outcome of the hearing was that you had failed to comply, then at that time, the court could revoke your community control, sentence you to 6 to 12 months, and fine you $2,500. And if you were convicted of a new felony while under community control and were sentenced to prison for that sentence and the sentence in this case could be ordered to be served consecutively, meaning one after the other. Do you understand that?
Yes, sir.
All right, now the charge in this case alleges that on or about January 17, 2023 in this county, Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance with methamphetamine, violation of Section 2925.11 of the Ohio Revised Code, which is the charge of aggravated possession of methamphetamine, the fifth-degree felony with the potential penalties I described earlier. Now, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Have you discussed the charge, the evidence, possible legal issues in the case, possible defense you might try to raise at trial, and the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with her advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
Yes.
Has anyone threatened you to make you plead guilty?
Yes.
Now, on page 2, there are a couple of lines that are actually 2.5 that are printed and underlined in bold, but then part of the second and the entire third line have been scratched out to indicate it does not apply. So the agreement then, as it reads currently on page 2, is the defendant will enter a plea of guilty to the indictment, state defense jointly recommend community control and substance abuse treatment. Is that your understanding of the agreement?
Yes, sir.
Does anyone promise you anything other than that to get you to plead guilty?
Yes, sir.
Under the law, the matter of sentence is up to the judge, not the parties. So even though there's a recommendation as to what the sentence ought to be from both parties, that's not binding on the court. So if you plead guilty, the court is not required to follow that recommendation. You understand?
I understand, sir.
Do you hold any license or certification from any state governmental agency that regulates any occupation or profession in this state?
I have a class in Georgia.
Okay, but nothing from Ohio.
Yes.
All right. Now, you have certain constitutional rights you must understand before I can accept the plea. First, you have the right to have counsel, and Ms. Hatner's been appointed to be your attorney. Now, that appointment wasn't simply to try to work the case out, but to provide any defense that could be available to you under the law that you would like her to provide. So if you decide that you don't want to do this, that you want to defend against these charges, she will continue to represent you and defend you, including a trial, if that is what you want. Do you understand that?
Yes, sir, I understand.
Now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After those 12 are selected, the evidence would be presented, and then they'd be instructed on the law by the judge, and then that jury would decide by a unanimous verdict, meaning all 12 of them would have to agree, on whether the state proves your guilt. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you could waive, which means to give up in writing, your right to have a jury trial. In that case, you would have what's called a court or bench trial, meaning that instead of a jury, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that? You understand that?
Yes, sir.
Okay. Now, under the Constitution, Mr. Blunt, you have a right to confront the witnesses against you in open court and to cross-examine them through your attorney. So that means that any witnesses against you have to come into court, testify in front of you, your attorney, and anyone else is present. After the prosecutor is done asking questions, your attorney has the right to ask questions. That's called cross-examination. The purpose of that is to try to bring out evidence that helps your side of the case. Do you understand that?
Yes, sir.
Under the Constitution, you have a right to use the power of this court to compel or force witnesses to come into court to testify on your behalf, the same as the state. So if you have witnesses you're not certain are going to come in voluntarily, your request, the court will issue a court order called a subpoena, and that would force those witnesses to come to court to be able to testify if you wanted them to, even though they didn't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, meaning you cannot be forced to give evidence or to testify in this matter at any time. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. And if you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time. And no one's even allowed to comment about it except in one situation. If there's a jury trial and you do not testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
All right, now under the Constitution, you're presumed innocent of this charge until proven guilty by the state of Ohio on every essential element of the offense charged. So the burden of proof isn't on you to try to prove you're not guilty simply because you've been accused. In fact, under the law, you don't have to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally, you entered a plea of not guilty, which denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. If you change that plea today from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea will admit the allegation in the indictment, admit that it's a crime, that you committed that crime. And that plea will waive and give up all the rights I've described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what you plead. But with that exception, your plea of guilty will waive and give up your right to a jury or court trial, waive and give up your right to confront witnesses against you and to cross-examine through your attorney, waive and give up your right to use the power of the court to compel or force witnesses to be in court to testify on your behalf, the same as the state. Waive and give up your privilege against self-incrimination because you're the one saying you're guilty, so that's what's used to find you guilty. It'll waive and give up the presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It could subject you to being sentenced immediately by the court. And finally, it waives and gives up any right to file an appeal you think you may have had up at this point in the case. Now, if I should sentence you to the maximum sentence or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentence and entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Now, do you have any questions about the plea agreement or the conditions of that?
No, sir. I'm happy with the plea agreement. I'd like to get treatment because
Okay.
I came in here.
Well, just answer my questions, okay? All right. So you understand the charge and the possible penalty. Can you understand the plea agreement?
Yes.
And again, you understand the recommendation of sentencing is not binding on the judge.
I understand.
You understand the constitutional rights I explained.
Yes, sir.
And you understand the plea of guilty, what it means and what the consequences will be.
Yes, sir.
I didn't say this to you earlier, but if you need to speak with Ms. Hatner, I can put you and her onto a breakout room in the computer. It would be just the two of you talking to each other, and no one else will be able to see you or hear you, and the deputy would step out while that takes place. Do you have anything you need to speak with her before we go any further?
Sir.
All right, then it's your decision to withdraw your not guilty plea and plead guilty to this charge pursuant to the terms of plea agreement.
Yes, sir.
All right, then as to the charge which alleges that on or about January 17, 2023 in Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance to wit methamphetamine in violation of Section 2925.11 of the Ohio Revised Code, a fifth-degree felony carrying possible sentence of incarceration of 6 to 12 months and a fine of $2,500. How do you plead?
Guilty.
All right, the court finds on this day in open court, the defendant was advised of all his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal Rule 11. The pleas accepted and were filed. Defendant is found guilty of the charge. The court refers the matter to the probation department for a pre-sentence report, which shall include an assessment for substance use disorder treatment and/or mental health assessment. And sentencing will be set for June the 4th at 9 a.m. Bond will be continued. In the event that the defendant is a candidate for residential treatment, the court would consider a motion to modify his bond to an OR on condition he be in treatment while we're pending sentencing. So that'll have to be filed by motion. So, all right. Anything further from counsel?
No, Your Honor.
All right. Thank you.
Thank you.
All right. Christine Kennison. All right, this is case number 25, CR 48, State of Ohio versus Christine Kennison. You're Christine Kennison, appearing on the screen. Mark Randy Schultz, case manager.
Yes, sir.
All right. This is a Zoom hearing. The defendant's attorney is Jacob Wagner, is appearing from his office, appearing from the prosecutor's office, Prosecutor Collins. The defendant is charged in a 10-count indictment, 5 counts of aggravated trafficking and fentanyl-related compound would be 2 counts or 3 counts, 2 counts of aggravated trafficking of methamphetamine, and then there are 5 counts of possession of those substances. This is a final pretrial. Trial is set for June the 9th. All right. Now, where do we stand on this case, counsel?
May I, Ms. Collins?
Yes.
Your Honor, we've got a plea worked out. Everything's resolved. I didn't get the plea form done with my client today. She was in. Long story short, Judge, we said it's for a plea date. We just didn't get the form back. She was in the group. But the form is down there with her. I've not got it back yet. No form for her.
All right. Okay. Well, just go ahead and as soon as we get done here, if you want to contact Ms. Lawyer and get a date set, we'll get that done. You know, we're talking about a plea in which will be an immediate sentence, or is it going to be a PSI?
PSI, if I may, sir, there's a plea with incarceration, but judicial release shortly thereafter, so we can get the PSI done beforehand, so you can use it for the judicial release, Your Honor.
Yeah.
And she's in counseling now, so she's not going.
All right. Well, then we can do it by Zoom then, since it'll be a PSI. All right. So, Ms. Kennison, we'll get in touch with your attorney, get in touch and get this set up. We'll try to get it set up next week and do it by Zoom. Okay.
Thank you, sir.
All right. Thank you. Okay, this is case number 25 CR 1016, State of Ohio versus David W. Everhart. And you're David W. Everhart, appearing there from the probation department. All right, you're muted there, Mr. Everhart. There should be a little red microphone with a slice through it in the lower left-hand corner of the screen. If you tap on that, it'll say unmute, and you click that. All right.
Okay.
Mr. Everhart's attorney is Sarah Barber. This hearing is being conducted by Zoom, and she's appearing from her office, appearing from the prosecutor's office, Prosecutor Collins. The defendant's charged with one count of aggravated possession of methamphetamine, a 53 felony. This is, I believe, the first pretrial, and final pretrial is set for June 4. And the trial date is set for June 12. I see that the state's provided discovery and the defense as well. So is that complete discovery, Ms. Varga?
Yes, Your Honor.
All right. And there are no pretrial motions?
Not at this time.
All right. And where do we stand on the resolution of the case?
I received an offer from the state, and I made my client aware of that offer. He's going to...
Your attorney there, Mr. Everhart, so you can discuss that with him. All right. All right. Anything further from counsel?
No, Your Honor.
All right. All right, this is case number 25CR041, State of Ohio versus Ryan Todd Graves. Present for the state is Assistant Prosecuting Attorney King. Present on behalf of the defendant is Attorney James Chandler. And you are Ryan Todd Graves?
Yes, sir.
Mr. Graves is charged with tampering with evidence, a third-degree felony, and aggravated possession of methamphetamine, a third-degree felony. This is a pretrial and final pretrial trial set for June the 9th. You've been presented with a plea of guilty form here, Mr. Graves, which indicates that you're going to withdraw your not guilty plea and plead guilty to count 2, aggravated possession of methamphetamine, under section 2925.11 Ohio Vice Code, third-degree felony. Now, this is a 3-page document. On page 3, there's a sentence that reads, "I enter this plea voluntarily." Right below that looks like the signature, Ryan T. Graves. Is this your signature I'm looking at?
Yes, sir.
And did you just sign this document this afternoon?
Yes, sir.
Now, when you signed it, did you understand that it's an agreement to plead guilty, which means there won't be a trial, and the next step in your case would be a sentencing?
Yes, sir.
Now, I know you came up from the treatment facility with Mr. Chandler, but were you aware of what was going to happen here this afternoon?
Yes, sir.
So you've been discussing this plea agreement with him before?
Yes.
And do you feel you've been rushed or pressured in any way into doing this?
No, sir.
Are you going forward today voluntarily?
Yes, sir.
All right. The agreement then further states that you understand that the potential penalties for the offense are 9 to 36 months imprisonment, a fine of $10,000, a mandatory fine of $5,000. And the form says a license suspension, but that's been eliminated by the state. The General Assembly passed a law went into effect last month that takes that off the table. Now, you understand that penalty, the penalties for that?
Yes, sir.
All right. And are you facing any felony charges anywhere else?
No, sir.
Are you currently on probation, parole, community control, or post-release control for a felony?
No, not other than here, sir.
Okay. Now, under the law, if you should be sentenced to prison and serve a prison term, upon completion of that prison term, the law provides that as part of the penalty, the adult parole authority could, at their option, decide to put you into post-release control for a period of up to 2 years. They don't have to, but they can. If they do, you'll be supervised in the terms they set by a parole officer, or by a parole officer. If during that period of time they determine that you've not complied, they could return you to prison, even though you served the entire term set by the court, for a period of up to, in this case, half of your prison term for one or more violations. However, if you violate by committing a new felony, then in addition, whatever sentence could be imposed in that new case by that judge could also sentence you for committing that offense while under post-release control in this case to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. And if that occurs, that would be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
Now, this is not a mandatory prison offense, and so what that means is that the court's not required to sentence you to prison for the offense if you're convicted. The court can impose what's called community control or probation. And that means that instead of going to prison, you'd be put under supervision of a probation officer for a period of up to 5 years under the term set by the court. If during that period of time the probation department felt that you were not complying, they would file a written allegation of that with the court. There would be a copy given to you. There would be a hearing at which you would be entitled to have an attorney. And if the outcome of that hearing was that you failed to comply, at that time the court could revoke your community control and then sentence you to prison for between 9 and 36 months and fine you $10,000. However, if you were convicted of a new felony while under under community control and were revoked in whole or part because of that, then any sentence imposed in that new case could be served consecutively to the sentence in this case. Do you understand that?
Yes, sir.
Now, the charge in this case in count 2 alleges that on or about January 16, 2025, in this county, he knowingly obtained, possessed, or used a Schedule II controlled substance to wit methamphetamine, an amount that equals or exceeds bulk amount but less than 5 times bulk amount in violation of Section 2925.11 of the Ohio Vice Code. So that's the charge, the third-degree felony with the penalties I described earlier. Do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged you did it?
Yes, sir.
Have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you in any way to get you to plead guilty here today?
No, sir.
Now, on page 2, there are a couple of lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 2. State will dismiss count 1. State and defense jointly recommend community control and referral to drug court. Is that your understanding of the agreement?
Yes, sir.
Did anyone promise you anything other than that to get you to plead guilty?
No, sir.
Now, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreement that you should be given a community-controlled sentence, that's not binding on the court. And so if you plead guilty, once all the information has been presented, if the court feels that's not the correct sentence, you could get a sentence of between 9 and 36 months and a fine of $10,000. Do you understand that?
Yes, sir.
Now, do you hold any license or certification from any state governmental agency that regulates any profession in the state of Ohio?
No, sir.
Okay. Now, you do have certain constitutional rights, you must understand, before I can accept your plea. First and foremost, you have a right to counsel, and I know you employed Mr. Chandler to represent you. Now, if you weren't able to pay him to represent you, the court would appoint someone to defend you, an attorney to defend you. So the question I bring up is, are you entering into this agreement because you're worried about being able to afford to pay Mr. Chandler?
No, sir.
Okay. All right, now, under the law, you have a right to have a jury trial in this matter, in which 12 people would be selected from a group of citizens who live in Highland County that are summoned for jury duty on your trial date. After 12 of those individuals are selected, the evidence is presented, then the judge instructs those jurors on the law. Then that jury must decide by unanimous verdict, meaning all 12 of them would have to agree on whether the state proved your guilt. If you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up, the right to have a jury trial. In that case, you would have what's called a court or bench trial. That means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Now, under the Constitution, you have a right to confront the witnesses against you and to cross-examine them through your attorney in open court. What that means is the witnesses against you have to come into court and testify in front of you and your attorney and anyone else is present. After the prosecutor is done asking questions, your attorney asks questions. That's called cross-examination. The purpose of that would be to try to bring out evidence that might help your side of the case. Do you understand that?
Yes, sir.
All right, now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify on your behalf and save the state. So if you have witnesses you're uncertain are going to come in voluntarily, at your request, court issues a court order, that's called a subpoena, that forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come in and testify against you. Do you understand that?
Yes, sir.
Under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time in these proceedings. In fact, no one's even allowed to talk about it or mention that except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury that because that is your right, they can consider it for any purpose. Do you understand that?
Yes, sir.
Under the Constitution, you have presumption of innocence, which means you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So there's no burden on you to try to prove you're not guilty simply because you've been charged. In fact, under the law, you're not required to present any evidence at trial in your own defense. You may, but you're not required to. But whether you do present evidence or not, the burden of proof will stay on the state of Ohio to prove your guilt on every essential element of the offense by proof beyond reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. The not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights that I've just described. If you change your plea from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment, admits that it's a crime, that you committed that crime. That plea waives, gives up all the rights that I've described for you, except your right to have an attorney. You always have a right to have your attorney, no matter what your plea is. But without exception, your plea of guilty will waive or give up the right to a jury or court trial, waive or give up the right to confront witnesses against you and to cross-examine them through your attorney. The waive or give up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It'll waive or give up your privilege against self-incrimination, because if you say you're guilty, that's what's used to find you guilty. It'll also waive or give up your presumption of innocence because if you say you're guilty, the state doesn't have to prove you're guilty. It subjects you to being sentenced immediately by the court. And finally, it waives gives up any right to file an appeal you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence in the future, or in other certain circumstances, there could be a right to appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, sir.
Right. Now, do you have any questions about the charge or the possible penalty?
No, sir.
You understand it?
Yes.
Any questions about the plea agreement?
No, sir.
You understand that?
Yes.
And you understand the recommendation on the sentence is not binding on the court?
Yes, sir.
You have any questions about the constitutional rights I've explained?
No, sir.
Do you understand those?
Yes, sir.
Do you understand what the guilty plea means and what the consequences of that will be if you enter here today?
Yes, sir.
Is there anything you need to speak with Mr. Chandler about before we go any further?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge pursuant to the terms of the plea agreement?
Yes, sir.
And as to the charge in count 2, which alleges that on or about January 16, 2025 in Highland County, Ohio, you knowingly obtained, possessed, or used a Schedule II controlled substance with methamphetamine, an amount that equals or exceeds bulk amount but less than 5 times bulk amount, violation of Section 2925.11 Ohio Revised Code, third-degree felony, aggravated possession of methamphetamine, carrying possible prison term between 9 and 36 months, fine of $10,000, a mandatory fine of $5,000. How do you plead?
Yeah.
All right, thank you. Court finds on this day in open court, the defendant was advised of all of his constitutional rights, made no intelligent and voluntary waiver pursuant to Criminal Rule 11. Please accept an order filed. Defendant is found guilty as charged in count 2. Count 1 is dismissed. The court will refer the matter to the probation department for a pre-sentence report, which will include an assessment for substance use disorder and or mental health issues that might require treatment. The court will also refer the matter to the drug court docket. So as soon as we get done here, you need to go down to the probation department and let them know that you pled guilty, so you need to schedule your pre-sentence interview. And then you'll need to have a meeting with the drug court coordinator or case manager to interview you for determination whether or not you wish to apply to be in the drug court. Drug court's not something that's mandatory by the court. It's something that's a voluntary program that people that are on community control elect to participate in. And so they'll go over that with you and explain that to you. And if that's what you want to do, then you'll sign an application for that. We'll set your sentencing hearing June the 4th at 9 a.m. and bond will be continued. So you're going to get an assignment notice here from the bailiff and then go right down to the probation department. Anything further, Counsel?
No, Your Honor.
All right.
Your Honor, I would like
Thank
to
you.
point out, if I could, that Mr. Graves has already checked into a rehab facility.
Yes, I'm aware of that. Yeah, we knew that. In fact, I understand you went to pick him up, so
Yes.
they hadn't. We did not notify them. We weren't aware of that, so we thought it was going to be by Zoom. And but anyway, that worked out great. So I'm glad you did that. But yeah, well, I have a confirmation from them. They sent us a report. So it sounds like you're doing well. You need to stay there. So, all right. Thank you.
Thank you.